Okay, so I'm going to be making a presentation on how international labor standards become part of our law in Zimbabwe, how we utilize them and so forth. What I will do is just first to what you have been going through in your training, which you continue to have to go through. It always takes us to the starting point. For most lawyers, they try and draw a distinction between international law and what they call domestic law. That distinction is drawn in some circles. And then they will argue that the law is domestic law. Then international law will only come into being in some way here and there. You can apply law from an international perspective. And I think that some of you have studied international law. They developed some theories. I don't want to get into those theories. They are not useful. All right? It's the issue of when do you apply a rule that has been recognized as a rule of international law. Because there's such a thing called international law. And then that thing called international law does have rules. And once a rule has been established at international law level, how does that rule become relevant at a national level? That's the issue. All right? We all know how domestic rules are made. And in a domestic rule, we know it. Either it's our legislation, which is the Constitution or Act of Parliament or some statutory instrument, or it's our common law, and we can determine how we can say this is the rule of law in our country by going through the case law and then establish that this is part of our common law. And then we, of course, have other systems, custom, and so on. But at the end of the day, a lawyer properly trained in any legal system would be able to tell you that this is the law of Zimbabwe on the basis of this. But then domestic frameworks are not the only rule-making frameworks. International law does make rules. And that's what you have been trained. It does make rules. And when does a rule become a rule of international law? It's one thing, Andre. That's not what we are dealing with. That's what she's dealing with. But once it has become a rule of international law, how does it become part of this other set of laws that we have always said is domestic law? I'm sure I get you are getting where I'm going to. That's where my understanding of what I'm supposed to be presenting. All right? In that the assumption that there is these sets of rules. And then you went through conventions, all that, those are rules. And they're fine, they are rules. Now, but how do those rules then become those rules which we can enforce here? I must emphasize that these rules as rules at the national level, they remain relevant. They are enforceable there at the international level. That's not the issue. You can enforce them there. You are a member of the ILO. There's an ILO conference. There's an ILO whatever committee of experts. There's this. That's enforcement at that level. The enforcement we want is an enforcement at the local level where your client or my client or anyone's client can actually utilize and say, look, I'm saying this point. Why? I'm saying it because that's what is provided for under international law. Okay? So what I'm going to be presenting to you now is something that is already available written in detail. Some of you may not have had access to a copy of a book that was published. I think it was October last year. I can see Labor Law in Zimbabwe by Lovemore Madhuku. I'll give you a copy. I'll give you a copy after this presentation and so forth. Then that is all covered in the chapter. When Gamo was talking to me, it's all covered. From everything that I was saying is actually covered. The questions that I'm addressing. How does a rule of international law become part of your law? And how does it apply to labor standards and so forth? So you get that. You have time to read it when you get an opportunity. Remember library, I think, and so forth. So I think the starting point is that it's always recommended that whenever you have these kind of questions, look around to say, has there been any publication around that question? And it will be an act of negligence, I think. If a person says, no, I'm not aware of any such thing having been said out, etc. Right, so we all know that the constitution of our country is the supreme law of the land. We all know that. If a thing is contrary to our constitution, it is not law. Doesn't matter what the United Nations says about it or what the ILO says about it. What matter? If our constitution says it's not law, that's the end of the matter. Yes. That's why you need someone to say that. If our constitution, she will come, if our constitution says this is not law, it doesn't matter what anyone else says. And I want to remind you, we had a similar situation with the commercial farmers at some point. All right? The constitution said, look, if your farm is taken, you have no access to a court. And then they went, Zimbabwe is part of the SADC, where in terms of the SADC treaty, Zimbabwe says it shall respect what is called the rule of law. And the white farmers went to the SADC tribunal in Namibia. You are aware of that? Yes. To argue that the Zimbabwean constitution itself is contrary to Zimbabwean obligations under international law. They succeeded there, but lost here. And the only issue that, so they came back with a judgment, wanted to register, and the court said, no, you won't register. We cannot register that which is contrary to the constitution. Now, this is a fundamental point, and that it cannot be derogated from unless you are not lawyers. If you are lawyers in this country, law is law if it is enforceable by our courts, at least law for Zimbabwe. But Zimbabwe can actually have its obligations, undermining its obligations internationally. That is clear. So what does our constitution say about these things? It says it in section 327 of the constitution. Section 327 of our constitution. All right? The whole of that section 327 is all about the application of international law to any situation. So when you get an opportunity, I'm sure you have a copy of the constitution, you must look through to say, what does that section say? Now, for the sake of brevity, I'll just read a few portions of that section 327 for you to know what it says. Section 327 would define what an international organization is and so on. And such subsection 2 says, an international treaty which has been concluded or executed by the president or under the president's authority, A, does not bind Zimbabwe until it has been approved by Parliament. And B, does not form part of the law of Zimbabwe unless it has been incorporated into the law through an act of Parliament. Then international treaties define that section to mean a convention, treaty, protocol, or agreement between one or more foreign states or governments or international organizations. So there is no doubt that an ILO convention is an international treaty under section 327 of our constitution. Agreed. If you have an international treaty in the typical sense, or you have an ILO convention, it is a treaty under section 327. And that treaty can only become part of our law. First, it must be approved by Parliament. And those two things must happen. Approval by Parliament and incorporation through an act of Parliament. Now, obviously, if there's an incorporation through an act of Parliament without a formal approval, that's still an approval because Parliament passes these acts. But to have, that is what? Then they will indicate that subsection 4 says, an act of Parliament may provide that subsections 2 and 3 do not apply to any particular international treaty or group of treaties or whatever, if an act of Parliament provides. So in this country, we are allowed to pass a general act that says this class of conventions shall not require that procedure of going through an act of Parliament. And that is in subsection 4. In other words, Parliament can pass a law that says all ILO conventions shall not require the formalities of going through Parliament and then forming an act. An ILO convention ratified by Zimbabwe shall, without more, become part of the law. That is allowed by our constitution for Parliament to do that. But it must first pass an act to say that. Now, we do not have such an act. Clear? This one? Now, because we do not have such an act, every international treaty or convention can only become law if it is made part of our law in terms of an act of parliament. That is one way. Then the second way is in 326, section 326 of our constitution. Section 326 of our constitution is quite clear. It says that a rule of customary international law, what is described as customary international law, a rule of customary international law shall be part of the law of Zimbabwe unless it is inconsistent with the constitution or an act of parliament. That's what it says. So there is such a thing in international law called customary international law. And these rules of customary international law are easy to establish. Any rules that are quite notoriously followed at international level become part of what is called customary international law. You can refer to that and say this is part of our law. As long as there is no act of parliament that contradicts that rule. Is that clear? Now that would mean like more or less you can use it. Now that provision means that you have to first, what does the constitution say? What does an act of parliament say? And then you can only apply a customary rule of international law if there is no contradicting act. Now, so we have two sources so far. The first one is for an international treaty to become part of our law, there must be an act of parliament. All right? In the absence of an act of parliament, you may argue that it is part of our law via customary international law. And your source for that is section 326. You will argue in court what is meant. In other words, lawyers must develop knowledge of what is meant by customary international law. And it's automatically part of our law, except where it contradicts the constitution or contradicts an act of parliament. Then the third avenue is in section 327, subsection 6. I'm just looking for where it is quoted here, so I know it's rhetorical time. Okay, all right, that's fine. I think I can. All right, it says, when interpreting legislation, when you are interpreting legislation, every court and tribunal must adopt any reasonable interpretation of the legislation that is consistent with any international convention, treaty, or agreement which is binding on Zimbabwe, in preference to an alternative interpretation inconsistent with that convention, treaty, or agreement. Is that clear? This one. Now that means that another method of bringing in international treaties, international convention, international law is via interpretation. You have to be interpreting some legislation. You can't do it from the air. If you are doing it from the air, it must be under 326 under customary international law. But you have to cite some provision of the act and say this provision of the act means this. It means this because this interpretation is the interpretation that is consistent with international law. Meaning you must know what the international law says for you to support a particular interpretation. And you will be choosing that interpretation ahead of another interpretation which is inconsistent with international processes. Now, I have to tell you quite openly that that section will be interpreted by our courts to mean that you only do that if there is some level of ambiguity. Are you getting my point there? Our courts will tell you, as lawyers here. So you have to go to court prepared for that argument. You don't just go to 326. That's what our courts will say. That's what our Supreme Court will say. If a word admits of no other meaning except that meaning given, we will go with that meaning. The only time you resort to 326 is there are two possible interpretations. You must adopt any reasonable interpretation. You get that? A reasonable interpretation assumes that there is some comparison with some other interpretation which is unreasonable. All right? There will be, and so on. So you must do that in preference. Mawedzo ari kuita handika. Vane word rokuti in preference. Section 326 means that there would be 2 or more possible interpretations. And then we have to pick which interpretation do we take. The interpretation that is favored by international law is the interpretation that you will follow. That way, Section 327, subsection 6 is not a new thing. That has always been a rule of interpretation in this country. Those of you actually, if I don't remember, interpretation of statutes, all right? Some of you university did in first year and so forth. But if you remember well, whenever the legislature is not presumed or is not presumed to be intending a result that is contrary to the international obligations of the country, that is a common law rule of interpretation. And that is what we have codified. But in giving it constitutional status, we have raised that rule. A court has no choice, but it has to take into account that approach, etc., etc. All right? That tells you that there are 3 ways in which a rule can be adopted. All right? Let me summarize them. The first one is that it must actually be taken through an act of parliament. That is the easiest one and the most recommended, which requires political will. You have to convince the parliament to take that route. If they do not do that, you can play around with the rule on customary international law. But the weakness of that approach is that customary international law will not apply ahead of a statute. Then the third thing is that you must utilize the avenue of interpretation. And when you interpret, you put it in. That's what takes me to that section 2A of the Labor Act